Hello and welcome to One and All Present. My name is Lakshya Jolly and I'm an intern at LEXIS and Co. The topic for the day is Arbitration and Conciliation Amendment Bill 2021. With growing number of businesses, it is only common that there will be numerous deals and not all deals turn out the way one would expect. Often at times there are certain unfortunate circumstances which will lead to an unexpected fall in the deals, and instead of going through a lengthy procedure of suing the defaulter party, many parties seek to go through with arbitration and conciliation. Arbitration conciliation is a form of dispute resolution in which a dispute is resolved outside the judicial court by an arbitrator who is not a party to the dispute and will make a binding decision on the dispute, and parties can mutually agree to it. On February 4, 2021, the Arbitration Conciliation Amendment Bill 2021 was tabled in the Lok Sabha. It aims to change the 1996 Arbitration Conciliation Act. The Act includes rules for domestic and international arbitration as well as a definition of the law governing conciliation proceedings. The bill repeals an ordinance enacted on November 4, 2020 that had the same requirements. The amendment to this act seeks to bring in three specific changes. This is because of the increasing corrupt practices which are going on to secure arbitrary rewards. The statement of objects of the amendment are as follows. To begin with, Section 2 of the Amendment Act modifies Section 36 of the original Act. The execution of arbitral awards is dealt within Section 36 of the Principal Act. An interim award is included in the definition of an arbitral award under Section 2C of the Primary Act. Section 36, subsection 3 gives the court the authority to postpone the execution of an arbitral judgment and provide written reasons for doing so. The procedure to be followed by the courts in circumstances where an arbitral award has been made in payment of money is prescribed in the provision to the subsection. The amendment adds a phrase to the provision following the court to postpone the execution of an arbitral award if there is prima facie evidence that the award or the contract on which it is based was tainted by fraud or corruption. The award might be put on hold indefinitely by the court until it's challenged under Section 34 of the Act. According to the Amendment Act, this clause will take effect retroactively on October 23, 2015. The Modification Act Second Amendment, made through Section 3, is the Section 43J of the original Act, which replaces the unamended clause with the following. By way of the 2019 Act, Section 43J was added to the main Act. The unamended Act which stated that arbitrators' qualification would be determined by those listed in Schedule 8 of the Act. The Primary Act Schedule 8 was omitted in the final revision according to the Amendment Act's Statement of Objects and Reason. This detection was necessary to allow eminent arbitrators to participate in Indian arbitration procedures, ensuring that India is promoted as a center of international commercial arbitration. The Amendment Act, like all other pieces of legislation, is not without flaws. One of the is modification to Section 36, which gives them already overworked Indian courts more leeway in determining whether an arbitral judgment prima facie contains elements of fraud. The deletion of the main Act's 8 schedule broadened the scope for the appointment of foreign arbitrators and arbitrators in a variety of professions. However, it may result in the appointment of inept arbitrators. The parties, councils, and Indian courts will have to verify arbitrators' competence. Again, which is unfavorable in this scenario, the council and the parties must proceed with the prudence when choosing arbitrators under the modified act. Despite these flaws, the truth is that that proper implementation of modified provisions will help to limit the number of cases when parties to arbitration proceedings are harmed by fraud and arbitral rulings. Only time will tell whether the council regulations will help designate appropriate arbitrators under the second portion of the Amendment Act. That was all. My name is Lakshya Jolly and thank you for watching the video.